A thin rectangle of light appears on the room's wall. An incoming push notification projected from the judge's remote monitor. Not the chorus of phone buzzes the gallery expects, but a single bright square that blooms and then multiplies, each new box carrying the same thumbnail, a blurred corner of the courtroom, the back of a witness's head. People do not look up at once. They stare at the lit rectangles as if the light might explain itself. On the defense table, Conrad Hale's pen moves before his face does. He draws two heavy letters across his pad, MISTRIAL, block capitals, underlined twice. He does not hide the thought. The word is a lever. His fingers drum it into the paper like a man testing a door for weakness. Across the aisle, ADA Avery Sinclair does not reach for a note. Her eyes go to the witness, quick, protective. She leans just enough to place her hand flat on the legal pad, a silent brace. The witness's hands, which had been steady, flex and go still. Avery's jaw sets. Her concerns are not strategy. They are custody and safety. Maya Johnson arrives at the bench with the quiet speed of someone who has already done this in her head a dozen times. She rests the tablet on the ledge. Her thumb hesitates over a highlighted timestamp. 3 seconds. Then she tucks a frayed ribbon she keeps in her pocket and murmurs, "Ma'am, that clip matches the court's digital recording pilot feed." The gesture is small and human. The ribbon is old, a keepsake from her summer internship. And for a beat, it reads like the kind of thing someone carries to make the job feel less sterile. Rowan hears the technical fact and reads the room at once. She does not let the speculation grow. She says, flat, "That feed isn't public. Who accessed it?" The courtroom waits. Camera operators in the press gallery check angles. Jurors shift their weight as if the whole building had become a question. The defendant watches his attorney's handwriting. A clerk at the side table reaches for a stamped ledger. No one speaks. Rowan puts her hand on the gavel and taps once, soft but absolute. The sound does not demand noise. It demands order. "Court stands in recess," she says. Then to Maya, in a voice that leaves no room for debate, "Preserve every recording. Preserve every access log. No copies, no distribution. Contact County IT. Now. Issue a system hold. We reconvene for an emergency proceeding on this breach." Maya nods and begins typing, the tablet reflecting a face that has already moved from worry to work. Outside, someone posts the clip with a line about transparency. Inside, the judge's command settles across the courtroom like an instruction. The day's chaos will be handled within the law. Rowan's eyes sweep the room once more. She does not ask a question. She sets the boundary. "Protect the record," she says. "Find how it left this room." The clerk's console hummed under Maya's palms. She tapped the case number into the screen, opened the file, and pulled up the protective order. The words were there in black ink. Protective Order 21C. No copying, no distribution. She thumbed the timestamp on the video the bench had flagged and typed a short instruction into the emergency channel. Preserve. Image. Hold access. Conrad Hale did not sit. He snapped a pre-printed motion form from a manila stack and found a pen. He did not write "Mistrial" again. He circled the form's title, "Motion for Change of Venue," and folded the sheet to show the clerk. He slid it across with a small practice flourish of a man who smelled opportunity. The motion's edge flashed like a card thrown down the table. Across from him, Avery Sinclair rose and walked the rail. She put a hand on the witness coordinator's shoulder at the gallery and spoke a name into her ear. One syllable, clipped. "Olson, protective detail now." A bailiff moved without looking, pulling a thin jacket from a rack and stepping to the witness area. Avery's phone was already open to a DA contact. Her thumb left a steady trail of texts. "Request jury instruction, prepare remedial language, call cyber unit." Maya's phone vibrated. Eric Long from County IT texted, "See an auth token. Need subpoena for ISP. Can't pull provider logs without legal compulsion." Maya's fingers hesitated over the reply. She typed, "Eric, this is the court. Protective order 21C. Preservation hold. Authorizes immediate imaging under administrative authority. Initiate image now. I'll notify bench." She hit send, then watched the 3 dots of a reply that took too long. Eric's voice came over the line, flat through a speaker. "Clerk Johnson. Protocols require written request plus written authorization from IT security. We can do a live pull, but it degrades the chain. Best practice is preserved image with warrant. I need a formal authorization to start imaging. Otherwise, we risk spoiling evidence." Maya closed her eyes for a half beat. She knew the manual, the rack in the locked room, the air-gapped backups. She also knew what a delayed image would do to a case, a window of time for copies to multiply, for caches to clear. She turned to the bench and did not explain policy. She asked for command. "Your Honor," she said, voice even. "County IT requests written authorization. They will not image without it." Rowan lifted the corner of a legal pad and pinched the paper between finger and thumb. She glanced at the protective order, then at Maya, and then at Eric's line on Maya's face. "Contact courthouse security and inform county IT this court authorizes an administrative image," she said. "If they require a subpoena, the court will issue one. But do not let protocol stall preservation. No copies. No distribution." Conrad leaned forward. "Your Honor," he said, eyes clicking to the jury box, "we will argue prejudice. The public has seen the recording. The jury pool is contaminated." Avery did not flinch. She had already risen to her feet once and returned with a sheet of paper. She showed it to the bailiff, notes for a proposed jury instruction, then offered the page, face down, toward the clerk's console where Maya worked. "We can propose voir dire modifications and remedial instructions," she said. "But we must secure the record first." In the press gallery, a producer shouted into a headset and then rose with a reporter's calm. "Can the court release a statement?" she called. The public information officer pushed forward with an official pad. "We'll need a line from the bench," she said. Rowan's hand moved the gavel, not striking but tapping the rim to reclaim rhythm. "This court is part of a limited county pilot program for digital recording," she said. "The recordings are for official records and appellate review only. Protective Order 21C was entered prior to trial. That order remains in effect. Anyone who distributed any recording in violation of that order will face appropriate sanctions." The press rustled. Someone clicked a camera. The bailiff stepped to the doorway and closed it. Maya's watch told her the next moves. Coordinate IT, chain of custody forms, courier the image, drive to an off-site secure vault. She opened a fresh form and began filling the chain of custody fields before Eric could finish his sentence. Eric's reply was a problem dressed as caution. "We can image. but we'll need a secure transport and a signed acceptance of liability. Also, backups are staggered. Physical retrieval from off-site will take time, he said. His voice meant the clock was not the court's alone. Time would pass in minutes that felt like hours. Maya stamped the form with the clerk's seal and slid it toward the bench. "I'll coordinate transport and sign that acceptance," she said. "But I need an order for expedited access if they push back, and I need the DA's cyber unit on call." Her fingers moved fast, a map unfolding in short commands. Avery placed a call to the DA's office while she spoke to the bailiff. The prosecutor's voice was low but firm. "If there is any suggestion the recording could affect witness safety or jury fairness, we will move for emergency relief under the protective order. We will also request a temporary restraining order on further distribution." Conrad made a show of standing and stepping toward the clerk. He pressed the motion into the file tray with the ease of a professional gambler. "Judge," he said, "if we cannot assure an impartial panel, we will move to dismiss or change venue." Rowan's face did not harden. It set like the hinge of an argument. "We will follow procedure," she said, "preserve image, issue subpoenas where necessary, and set an expedited hearing on contempt and preservation. If a third party is found responsible for distribution, the court will consider appropriate sanctions. The main trial will remain stayed only to the extent necessary to preserve fairness." Maya exhaled and typed the chain of custody entry into the system. The clerk's eyes flicked to the doorway, where reporters clustered, and then to the jurors, who sat with the uneasy patience of people waiting for weather to change. The pilot program that promised clarity had pulled a thread. The court would stitch it back together, one lawful move at a time. 3 days later, the courtroom air was thinner. Judge Rowan took the bench at 9. "This proceeding is limited to whether Protective Order 21C was violated," she said. "We will determine responsibility for the distribution, not guilt on the main charge." Conrad Hale rose first. He presented a folded motion for change of venue, with a handwritten note beneath it. "Request expedited voir dire." He slid it across the table, then tapped the edge twice, a soft, precise ritual. Avery Sinclair stood and walked to the rail. She handed a small printed packet to the bailiff, a proposed jury instruction, and a witness safety request. "We ask the court to authorize protective measures for the witness and to preserve the jury pool," she said. She added, "We also request immediate subpoenas for the cafe's Wi-Fi logs and for the hosting platform." Maya rose and moved to the bench with a report. Her tablet showed a feed of system data. "The county IT image confirms an external download tied to an authentication token assigned to a staff account. That token was used off-site at 10:52 p.m. 2 nights ago. We have an external MAC address and a connection routed through a hotspot registered to a courier company. Jefferson Legal Runners." She looked up to gauge reaction. "We've flagged a pickup at the courthouse cafe at the same hour." The courtroom shifted. A courier company. Suspicion now had a name. Media counsel pushed forward. "Judge, the press will argue this is now public," she said. "Anyone who reports should be free to do so. A restraint on publication is a prior restraint." Rowan tapped the gavel once. "Publication and redistribution are distinct. Reporting on a matter is permissible. Reposting or circulating restricted recordings is not. The protective order remains in force." Trevor Knox's attorney rose. "My client received the clip from a delivery he knows only as Mac. a runner who sells footage to creators. He paid for a file that arrived via file share. He never asked whether it was restricted. Knox swallowed. Rowan's eyes narrowed. You believed a paid file from a runner without verifying provenance? No, Your Honor, Knox said. I didn't check. I thought it was public. That admission landed like a flat stone. The bailiff's phone buzzed. He glanced at the screen, then looked up with a color to his face. Your Honor, an upload was just posted to a new account with additional audio not present in our archive, he said. An audible intake circled the room. Avery's hand went to her packet. Maya's fingers flew to the tablet. The new clip had been altered. Someone had added a few seconds of off-mic commentary, a voice that did not belong in the recording. The edit suggested deliberate tampering, not mere improper sharing. Rowan did not smile. She folded her hands. That changes the scope, she said. If the recording has been edited after distribution, we face possible evidence tampering and obstruction. I will add that to the subpoenas. Conrad watched Rowan's face, then reached for his pen. He pressed the tip against the paper without writing. He did not speak. He closed the pen slowly and placed it on top of his motion, then pushed the motion slightly forward so the corner peered into the judge's sight line. Avery moved before she spoke. We request immediate TRO against redistribution and a preservation order for all related accounts. We also ask the court to authorize expedited warrants for the courier company and the hosting platform. Her list was terse and functional. The altered clip is reason to suspect malicious manipulation. We must freeze the chain. Media counsel stood again. A temporary restraining order on publication risks unconstitutional prior restraint. We will move to vacate any order that suppresses reporting. Temporary and narrowly tailored, Rowan answered. It will restrain replication of the restricted file only. Reporting remains allowed. We are not silencing words. We are limiting the spread of stolen or altered material. She paused, then set the TRO in motion. Clerk, issue subpoenas for Jefferson Legal Runners, the cafe's provider, and the platform hosting the upload. Coordinate with County IT and the DA's cyber unit. Serve the temporary protective order limiting redistribution and reproduction of the restricted recording. Reconvene on findings in 7 days. Maya printed the TRO, stamped it, and passed copies to the bailiff. Her hands were steady, though her jaw tightened. Outside the courthouse, someone typed the new uploads link into a search bar. Inside, the court harness processed to slow down a storm. Conrad rose but did not speak. He folded his motion, placed it deliberately into the file tray, and tapped the top twice, the same small ritual as before, and sat. Rowan looked over everyone in the room. Order is not preference, it's a requirement, she said. We will follow the facts. We will protect the trial's integrity. We will not let headlines determine law. She set the date for the expedited return, and the bailiff closed the doors. The murmurs outside rose like tide. As the court emptied, Rowan's question lingered. If you saw it, what would you do? A week later, Eric Long from County IT stood by a terminal displaying the server's forensic image. Maya handed a timeline to the bench. Key points: auth token used at 22.52. Transfer complete 18 seconds later, she said. The IP routes through a public hotspot, which shows a device registered to Jefferson Legal Runners at that hour. Rowan's question cut straight. Who used that credential? A courthouse staffer, Thomas Reed, stood. I signed for a runner's package. he said, his voice small. Mac handed me a drive and a receipt. I put it in my bag, unopened. Conrad Hale leaned forward. You signed for court material? Thomas looked at the floor. It was a packet. I thought paperwork. I didn't know there was audio. Avery Sinclair did not ask for drama. She asked for facts. Did you log into any court systems that night while you were out? No, ma'am. He rubbed his thumb on the edge of the torn receipt he still had. I clocked out, walked across the street, got coffee. Mac asked me to accept a drop. I signed. Maya tapped the timeline. The token indicates staff credentials were used from a location consistent with that hotspot. That suggests either session hijack or credential misuse and an immediate handoff to a runner. Eric Long spoke from the terminal. The hotspot is public, making attribution difficult. Worse, there's a VPN hop masking the origin. Rowan summarized. So, a courier receipt and an anonymizing hop. Eric's tone grew frank. Best practice is to image the server now before evidence degrades, but our IT policy requires a written court order. Avery cut in. Protective Order 21C is your authority. Don't let policy become an excuse for delay. Rowan watched the exchange and then made the call. Coordinate the imaging under court authority immediately, she said. If IT requires forms, have them by noon. Move on subpoenas for Jefferson legal runners, for the hotspot provider, and for the hosting platform. Notify the DA's cyber unit and deploy U.S. Marshals for chain of custody security on any seized devices. Maya exhaled and started the paperwork. She paused only once to look at Thomas. Did Mac leave a number on the receipt? She asked. Thomas produced a torn, coffee-stained slip. He left a number, he said, his fingers shaking, and a note. Runs for firms. I never thought... The detail made him human. Careless, not planted. Maya handed the slip to Eric. He photographed it into evidence. We'll subpoena call records and the courier company's logs. If Mac is a reseller, we trace sales. If Mac is an employee of Jefferson Legal Runners, we subpoena payroll and dispatch records. Outside, the court's PIO, with Maya beside her, read a plain statement. The court has imaged the server and issued subpoenas. The investigation is ongoing. Maya then added the key timeline points, offering facts, not opinion. Eric tapped the screen again. That VPN hop is the real complication. If the file passed through an anonymizer, we may have an intermediary deliberately covering tracks. That expands the probe beyond a careless handoff. Conrad folded his motion and slid it into the tray. He kept his eyes on the docket, choosing his moment. His silence was now a tool of patience rather than defeat. Avery's list moved forward. Subpoenas for ISP and VPN provider, preservation orders for Jefferson legal runners, warrants if hardware is located. If we find evidence of intentional concealment, she said, criminal referrals will follow. Rowan set the schedule. Return in 7 days with an initial forensic summary and confirmation of service. If we have malfeasance, we will expand the inquiry. If negligence, we will consider administrative sanctions. For now, she paused and fixed the room with a look that was both quiet and absolute. A log-in is a small act that can break a room. Who watched when the room lost its privacy? No one spoke. The question moved from the bench to the press and into the city's feeds. Subpoenas left the clerk's desk like commands. The investigation was no longer rumor. It was procedure, slow and exacting, and it had a human center. Thomas's torn receipt, a courier's uncertain identity, and a team split briefly by method, but united by the need to find how the private became public. They met in chambers, away from microphones and camera angles, but the room felt like a stage anyway. Conrad Hale arrived with his folded article and a business card tucked into the crease. He laid the paper on the table and, without looking up, slid the card under it so only an edge showed. It was a small thing, political, suggestive, that read like someone keeping options open. He spoke about public interest with the practiced cadence of a man who knew headlines mattered. The card's hidden edge, though, kept a question in the air. Whose audience did he answer? Avery Sinclair did not trade rhetoric. She handed the judge a slim file. Inside were still frames from the edited clip and 2 printouts of direct messages someone had sent the witness after the first upload, one anonymous, one from a burner account. The messages were blunt. "Shut up or we'll find you," and a location-tagged photo of the witness's neighborhood. Avery let the paper slide toward the bench. "This is not hypothetical," she said. "The witness received threats within hours of the recording's release. We have copies. She is scared. We have her relocation request in process." The media counsel, a calculated woman with a quick smile, leaned forward. "Judge, the press exists to inform. If information has entered the public domain, the public has a right to see it. Prior restraint is extreme." Rowan listened. She folded the edge of a notepad between her fingers as if weighing the grain of paper itself. "The issue is not access to reporting," she said. "It is the distribution of restricted recordings obtained in violation of a court order, and now, the weaponization of those recordings to threaten a witness." The counsel's smile stayed, but her eyes flicked. "If the recording is used to intimidate, that raises real concerns. But limits on publication must be narrowly tailored. The press will not be muzzled." Avery pushed the folder a fraction closer. "Judge, the messages were tagged with the witness's apartment complex. Security has documented 2 suspicious vehicles circling that block since the leak. She received a voicemail with a distorted voice saying she should keep her mouth shut. That is not abstract. That is a tangible risk to her safety and to the fairness of this trial." Conrad made a small motion. No words. He pulled a paper from his briefcase, a signed affidavit from a prospective juror reporting they had seen the clip online and formed an opinion. He folded the affidavit and laid it on the table where everyone could see. His hands did not tremble. His calm did something different now. It felt like calculation that might also look like strategy. The presence of the juror's note made the risk real for the bench, but the folded card from earlier kept his motives shaded. The media counsel's jaw worked. She inclined her head as if accepting a point, then added, "We will accept a narrowly tailored restriction on distribution, provided it applies only to the recorded file and not to reporting about what occurred. However, we will ask for prompt access to unredacted transcripts and an opportunity to challenge the scope of the order." Her voice was smooth. The add-on was a warning. Compliance for now, pressure later. Rowan fixed her gaze on the lawyers. "We balance rights," she said. "We do not abdicate duty." She tapped the table once. "Temporary protective order. Distribution and republication of any courtroom recordings are prohibited. Written coverage and commentary remain permitted. Any party who republishes the restricted file will be subject to contempt proceedings. This restriction remains in effect while the court completes its investigation into the source and any tampering." Avery exhaled. But her next words were firm. We also need interim witness protections, relocation assistance, a security detail at courthouse appearances, and redaction of identifying details in public filings. Granted, Rowan said. Clerk, coordinate the witness security measures and forward the request to protective services. DA, prepare emergency applications for the same. Conrad did not protest. He folded his hands. Not in retreat, but in patience. He folded them so tightly the knuckles brightened. The small, unspoken thing, his cards snug under the op-ed, felt like a quiet promise to push later if opportunity opened. The counsel for the press rose. Judge, we note the court's narrowing of the order and reserve the right to file for immediate review should the order unduly restrict reporting. Noted, Rowan said, and you will receive redacted transcripts under protective procedures. Maya read the TRO aloud into the record, voice steady and controlled. Distribution and republication of court-recorded audio and video is prohibited pending further order. Written reporting and commentary are permitted. Violations may result in contempt. A knock at the door interrupted the formality. The bailiff handed Rowan a small envelope stamped with the DA's seal and a notation. Possible tampering detected in new uploads. Rowan scanned the note, then looked up at everyone in the room. Preserve, trace, and serve, she said. We will reconvene on the contempt hearing in 7 days, with forensic summary and service confirmations. If edits show tampering, we will expand to obstruction or evidence tampering charges. Outside, the press would parse the compromise into headlines. Inside, the room had bought a week to let process do the work of truth-finding. Conrad's card still sat under the op-ed, a small edge of ambiguity. Avery's file had a heavier weight now, screenshots of threats that turned theory into imminent danger. Maya's hands had filed the order and set the wheels in motion. The court had narrowed the line between speech and harm. The line would be tested in the days ahead. Rowan's closing line was not a question, but a charge. Noise is not transparency. Protect the witness. They resumed 2 weeks after the leak with a courtroom full of printed threads and a quiet that tasted like consequence. Thomas Reed sat so still he looked smaller in the chair. His badge lay beside a packet of exhibits. A young lawyer, Paul Lang, stood to speak for him. Conrad Hale remained at the defense table across the room, an observer now, his folded cards still in the file. He watched with the narrowed attention of a man who catalogs advantage. State's Exhibit 1, Avery began, and slid a thread across the bench. Mr. Reed, you testified previously that you clicked a link you believed to be an IT notice. Is that correct? Thomas blinked. Yes, he said. His voice had the thinness of someone who has been through the mill. It looked official. I typed the token and it froze. I didn't think... Did you have any contact with Trevor Knox before the leak? Avery asked. Thomas hesitated. His fingers absently smoothed the torn edge of the receipt he'd kept. He messaged months ago, he admitted. I didn't answer. He stopped. The word caught at the throat. For a breath, he looked at Paul Lang, then at the bench. He asked if anyone had raw courtroom files, Thomas said finally. I thought it was spam. Eric Long at the IT terminal interrupted, his voice thin with focus. We found a call log entry that correlates, he said. On the morning of the leak, a short-duration call went from a number linked to Knox's network to Thomas's phone. The call lasted 38 seconds. It's prior to the access timestamp by about an hour. A ripple moved through the room. Thomas's head jerked involuntarily. He frowned, then opened his mouth and closed it. I don't remember that call, he said. The words were small and not quite steady. A new panel of doubt slid under his statement. Paul Lang stepped in with the lawyer's quiet. My client worked late shifts. He picks up runs. He deals with couriers. A call could be anything. Orders, scheduling. We do not have proof of coordination. Eric flipped a page of printouts and pointed. We also found transaction records. A micro-payment of $50 cleared an account tied to a disposable payment method in the 48 hours before the leak. The receiving account traces to a wallet used by Contempt affiliates connected to Knox's channels. Avery's response was immediate. That shows incentive. Payment, message, and then a short call. The elements align with a targeted solicitation. Conrad's face did not change, but his fingers tapped once on the edge of his file. The motion he had prepared earlier lay untouched. He watched Thomas as if reading a slow script. Small nods here, slight inhalations there, gestures that said he understood the contours without saying them aloud. His silence weighed. It was an instrument. Thomas's eyes darted to Conrad for the barest second, then back to Paul. I didn't take money, he said. I only signed for a drive. I put it in my bag because I was asked to. I was tired. I didn't open it. Avery held up a printout of a message thread. Mr. Reed, this message was sent to you 6 hours before the leak. Need raw clip tonight. Can you help? Pay on delivery. Your phone shows a credit to a disposable account 2 hours after the transfer. She slid the paper forward. Which is it? Error or arrangement? Lang's jaw tightened. Your Honor, a timestamp is not a motive. My client was careless and naive in handling deliveries. Carelessness is not conspiracy. Eric added another technical note. The VPN hop complicates origin, but the payment trail and the call are corroborative. We have no smoking gun showing Thomas accessed the server directly. We have a pattern that suggests facilitation. Rowan folded the evidence in her hands as if weighing metal. Mr. Reed, she said, each word paired to necessity. You kept the receipt. You accepted a drive. You had an earlier message. You then had a short call around the time of the transfer. Tell the court the full truth now. Thomas swallowed. This time he did not look at Paul. He looked at his own hands, palms rough and quick with habit. I signed for a courier before a double shift. I remember the call now. Someone said they were picking up paperwork for a partner. I thought they meant a file. I didn't check the contents. I didn't know it was recording. I didn't know about the payment. His voice rattled on the last phrase, thin as lint. There was a flicker, an almost smile of someone trying a way out. No one laughed. Avery's eyes gripped the moment. If your phone received a payment, we can verify. It's not merely forgetfulness. It moves from negligence to possible complicity. The DA's cyber unit will need full device images and banking probes. Rowan's jaw tightened, but she did not make a judgment in the instant. We will refer all findings to the DA for potential criminal inquiry if the correlations show coordinated solicitation. Mr. Reed will be placed on administrative leave pending that referral. Paul Lang rose, voice soft but urgent. If he is punished for a mistake, it will ruin him. We ask the court to consider proportional measures if the investigation shows only negligence. Conrad's hand flicked, a tiny motion, the kind that suggested he'd make a record of the exchange for use later. It did not go unnoticed. Maya placed the chain of custody folder on the bench. All items collected were sealed and logged, she reported. We've provided the DA's cyber unit with server images, phone images, the courier slip, and the transaction records. They are in custody now. Rowan looked at the files and then at Thomas. Intent draws the line between mistake and malice, she said. This court will not criminalize the careless without proof of complicity. But if complicity exists, we will not ignore it. She set the calendar. Return in 1 week with preliminary findings from the DA's cyber unit. Mr. Reed remains suspended pending that report. Thomas folded into himself, the lines on his face deeper now. The courtroom felt smaller. The click that began it all had sharpened into a legal fracture. Outside, the feeds spun. Inside, the law wound toward the narrow place where error met intent. They came back into the courtroom with precedent and pressure in equal measure. Rowan had her authorities laid out, but she also had a memory tucked behind the law, a case that had once bent a courtroom until it broke, and a smaller one that had left scars she still carried. She began with the precedent and then made it personal. In Shepard v. Maxwell, the Supreme Court did not merely reverse a conviction, it dissected what happens when a trial becomes a spectacle, she said. A man's wife was murdered. The press turned the courtroom into theater. Witnesses were harassed. The jury was drowned in headlines before a single piece of evidence was properly sworn in. The court held that where pre-trial publicity is so pervasive that no instruction can cure it, the defendant's right to a fair trial has been lost. She paused, and her voice dropped half a register. The room leaned in without knowing it. Years ago, I sat on an appellate panel reviewing a case with similar contamination. Not Shepard, but smaller. A state matter that never made the law reviews. A witness wrote to the court afterward. She said she couldn't leave her house for weeks. The recording of her testimony had been clipped, edited, and weaponized online. She was terrified not of the defendant, but of the public who had turned her words into ammunition. Rowan's hand rested on the bench, fingers still. That letter is paper I have not forgotten. Shepard taught us that once the well is poisoned, no instruction can purify it. We will not create another contaminated trial here. The media counsel leaned in. She had rehearsed the First Amendment line until it read like a prayer. Your Honor, Shepard was about carnival atmosphere, photographers in the jury box, daily front-page speculation, a complete breakdown of judicial control. That is not this case. We have a targeted concern about one recording already in circulation. If the material exists in the public domain, suppression is not only meaningless, it is dangerous to a free society. The public's right to oversee its institutions is fundamental. Prior restraint is the nuclear option in First Amendment law, and Shepard does not authorize it here. For a heartbeat, the balance in the room shifted. The counsel's argument sounded less like theory and more like a tide pulling at the bench. Reporters at the back sat up. The motion to vacate the TRO suddenly seemed within reach. Conrad Hale's eyes touched the counsel and then the bench. His posture sharpened as if ready to pounce on any fissure. Rowan held her note cards but did not answer immediately. The pause was thin, long enough for the motion to feel like momentum. Then Eric's exhibit lit the screen. A forensic comparison scrolled. The court's sealed master audio against the circulating clip. Small waveforms, then a highlighted splice, an audio insertion that did not belong. The edited segment contained a phrase lifted from another hearing altogether. That is manipulation, Eric said, quiet and exact. This is not concurrent reporting. It is an artifact designed to mislead. The counsel's confident line stumbled for a beat. Her mouth tightened. If that proves to be the case, then yes, the recording has been weaponized, she conceded. Her concession was careful, measured, and tactical. She wanted the court to recognize the manipulation, but also to push for access to correct the record. Rowan seized that opening. "We will not permit correction through the very means that harmed our process," she told the room. "Public correction requires a reliable source. The edit you show is not reliable. Prior restraint is a severe remedy, but unbounded distribution of manipulated recordings is not remedial transparency. It is chaos masquerading as oversight." Conrad's expression barely moved, but his hands did. He reached beneath his file, slid out the slim business card he had tucked earlier, looked at it with the casual interest of a man cataloging a tool, and then, almost imperceptibly, placed it back. The action was small, private, and meant for no audience except himself. It read like a bookmark in a strategy he was not yet ready to lay down. The media counsel tried one last move. "Your Honor, even with manipulation, an expedited disclosure protocol should be ordered. Let us review the unredacted recording under protective safeguards. Let us compare and publish corrections immediately. Transparency is the antidote to misinformation, not suppression." Rowan considered, then quoted the rule with the precision of someone who had written it into memory long ago. Rule 53 and analogous state law prohibit broadcast absent permission. Our county's pilot program explicitly limits recordings for archival and appellate use, not for real-time distribution. The court can facilitate review under controlled conditions, and will. But it cannot authorize public redistribution of material that was obtained in violation of a court order and which now shows signs of deliberate tampering. She turned her note cards to a lined note, where she had written a single phrase earlier. "Protect fairness. Enable verification." Her voice softened but did not yield. "The witness in that case I mentioned, the one who wrote the letter, she told us she felt safer in the defendant's presence than she did walking to her car. That is what happens when the court loses control of its own record. I will not let that happen to a witness here." The room absorbed the weight of that statement. It was not rhetoric. It was lived experience, spoken plainly. The court will arrange for vetted news representatives to review the unredacted file under supervision and under protective protocols, Rowan continued. They may challenge the court's conclusions through established judicial review mechanisms. That balances access with preservation, but let me be clear, this is not Shepard-level chaos yet. And we will keep it that way by acting now, not by waiting until the damage is irreversible. Avery added the practical layer. We will provide redacted transcripts where appropriate and make the raw recording available to credentialed press representatives in a controlled setting within 48 hours. But republication remains prohibited while this investigation continues and while the edited versions remain in circulation. The counsel's nod was slow and skeptical. She folded her hands and said, "We accept that framework, but we reserve the right to move for expedited judicial review if access is obstructed or if the timeline extends beyond what is reasonable." Rowan set the timeline with the exactness of a metronome. Return in 7 days with the forensic summary and confirmation of subpoena results. If manipulation is confirmed beyond dispute, the court will consider contempt proceedings and potential referrals for obstruction or evidence tampering. The temporary restraining order remains narrow and temporary, but it remains in effect. There was a moment of static silence, the kind that sits between a decision and its consequences. Then, the press room outside filled with the sound of keyboards. Conrad tucked his card back into the file as the bailiff began to shuffle papers. His motion lay there, undisclosed, and his face had a shade of calculation that made the rest of the room tighten in ways they might not acknowledge. Rowan closed the book of authorities and gave the bench its final line. "Law is a ledger of consequences," she said. "We will use it here to keep order where others seek only spectacle. Shepard reminds us that trials are not performances. They are processes, and process, when protected, is how we arrive at truth." She rapped the gavel once, precise as a heartbeat. As the courtroom emptied, the memory of Shepard lingered, no longer abstract but tethered to the present by Rowan's own recollection and by the spliced waveform that flashed on the screen. The precedent was not merely a citation. It was a warning carved into the law by a case that had failed its participants. The process would move forward now, measured and deliberate, binding law to fact and waiting for the cyber unit to tell whether the leak had been a mistake, a sale, or a plan. The court reconvened under a watchful hush. Rowan took the bench. "This court has reviewed the evidence," she said. "A restricted recording was distributed in violation of Protective Order 21C. Some circulating versions have been materially altered." She looked at Trevor Knox. The young man's face had gone pale around the jaw. He did not speak. He watched his attorney. "Mr. Knox," Rowan continued, "distribution of material protected by a court order is a sanctionable act. Civil contempt remedies are coercive and remedial, designed to secure compliance." Trevor's attorney rose, voice measured. "Your Honor, my client did not access the secured system. He received a file that appeared public. He did not intend harm. Punishing him with criminal sanctions would be disproportionate." Rowan nodded before delivering the ruling. "The record shows willful distribution after notice of the protective order. The court finds Mr. Knox in civil contempt." She announced the remedy. "Mr. Knox is ordered to pay a civil fine of $5,000 pursuant to this court's contempt powers and to perform 200 hours of community service with organizations that assist victims of digital exploitation. He will also publish, in coordination with the court's approved correction, a statement clarifying the manipulation found in certain versions of the recording." For a heartbeat, the courtroom held its breath. Then Trevor, lean and restless, turned toward his counsel and hissed under his breath, "They can't do this." "Make them not do this." The words cut like a snapped wire. His attorney placed a steadying hand on his shoulder, but did not answer aloud. The media counsel rose immediately. "Judge, these remedies verge on suppression of speech. A fine and mandated speech may chill reporting. We will challenge any aspect that infringes the First Amendment." Rowan met her gaze. "You may file a motion. The court balances speech with the integrity of the process. This remedy is narrowly tailored and civil, not criminal. It is aimed at restitution and correction." Avery moved forward with a sheet of proposed instructions. She spoke and then paused, just once, when Rowan accepted the jury protection measures. The pause was small but telling, a flicker of uncertainty that she had secured the protection she sought, yet worried about downstream appeals or whether the voir dire adjustments would hold up under scrutiny. We request adjusted voir dire questions to screen for exposure to edited clips, additional cautionary instructions, and temporary sequestration of certain voir dire materials, she said, voice firm but with an edge of concern. Rowan answered with procedural precision. Voir dire will be modified to screen for exposure to the recordings. The jury will receive cautionary instructions to rely only on evidence admitted at trial. These measures are implemented immediately. Trevor's lawyer made a final, sharper argument, less mitigation than a challenge. Your Honor, the finding of willfulness is contestable. The chain of custody shows ambiguity about how the file reached my client. A coercive fine imposed without criminal due process risks chilling speech. We will seek prompt appellate review and an expedited hearing on the contempt finding. Rowan's response was plain. Appeals are a right. This court's remedy stands pending review. Thomas Reed's administrative situation was addressed next. Mr. Reed remains on administrative suspension pending the DA's final review, Rowan said. Criminal charges will follow if the DA finds evidence of culpability. Otherwise, the court will consider administrative sanctions. Eric Long confirmed the safeguards. Forensic images remain sealed. Credentialed press may review the unredacted recording under supervision and protective protocols for verification only. He added that copies would not be provided and that any republication risked contempt. Rowan folded the ruling into the record and looked out over the gallery. Disruption has consequences. Guilt requires proof. Remedies here are limited, reviewable, and designed to protect the trial's integrity while allowing channels for transparency under controlled conditions. She paused, then gave the instruction the public needed. Voir dire. The court will ask potential jurors directly about exposure to the leaked material and their ability to set aside what they have seen. That is how we safeguard impartiality. Conrad Hale watched the ruling with slow interest. He cataloged each element: the fine, the community service, the voir dire language, his face an unreadable ledger of strategy. He did not stand to object. Instead, he collected his papers and the small ambiguous card he had kept as a personal token. He folded it away like a reserve argument. Outside, headlines would parse the punishment. Inside, the court moved forward with tailored steps, sanctions, a protected jury, and a pathway for criminal referral. The balance Rowan struck left no victory untested. The late light lay across the bench like a remembered fact. Rowan stacked the files, folded the docket, and looked once toward the gallery, where faces blurred into intent and opinion. This court has ruled, she said, low and steady. Freedom of speech ends where contempt begins. A soft tap of the gavel finished the sentence and the moment. The rim caught a flash of gold and then was still. Outside, the steps had become a field of argument. Protesters waving banners for openness, others calling for respect for process. Cameras rolled. Pundits shaped the day into narrative. In the lobby, a television screen replayed the edited clip again and again, each iteration losing a little more context. Inside, Maya watched the headlines scroll on her locked screen, then turned it face down. She logged the last entries: protective order active, DA referral pending, server sealed, and took the sealed drive Eric handed her. She slid it into the evidence cabinet, turned the key, and felt the small, decisive click under her fingers. Conrad Hale lingered near the counsel table, folding his papers with slow, practiced care. He did not speak. He watched Rowan leave and then met the media counsel's eye across the room. The counsel gave a small, measured nod, an agreement that was not friendship, but mutual wager. Both paused long enough for the camera to find them, then turned away, already calculating the next move. Rowan descended the bench. Her heels clicked once, twice on the marble. The sound read as punctuation. As she passed Maya, she leaned in, voice barely above breath. "Keep the record clean," she said. Not a public slogan, but an instruction given to someone who would carry it out. Maya nodded, the motion simple and absolute. The protective order stood. The investigation continued. Outside, the debate would rage. Inside, the court had restored procedure and set a narrow path back to truth. A question threaded the stairwell and the feeds. Should courtrooms stay private to protect the truth? Justice speaks softly, but loud enough to be heard. The questions raised in this courtroom have no easy answers. They require consideration, debate, and a community committed to finding the truth together. If these are the conversations you want to be a part of, subscribe to our channel. Like this video to let us know you value in-depth stories, and share it to bring more voices into this important discussion. Now, we want to hear from you. Tell us in the comments, if this were your courtroom, how would you protect the truth?